Please note that you cannot only because the Evidence Act is not an exclusive act or exhaustive act. The rules of evidence are included in the Code of Civil Procedure. Like, for example, the provisions of the provision relating to examination of witnesses under Order 18. Under Order 18, Rule 4, you examine the witnesses, you file your examination chief, isn't it? Then under the provisions of Order 16, you file the list of your witnesses. Then starting will be under the provisions of Order 7 of the Code of Civil Procedure. Order 7 of the Code of Civil Procedure, read with section Order 7 Rule 14, where the documents are first introduced. Then by the defendant introduces the document under the provisions of Order 8, Rule 1A, that we discuss it here. Then in the CRPC, so the introduction of the documents, you learned it in the plain, in the written statement, and also under the affidavit scheme under Order 11, Rule 13. Both the parties are required to file the affidavit. Then under the provisions of Order 11, Rule 22, Section 30, the court summons witnesses, interrogatories, documents. Then under the provisions of Order 11, Rule 7, discovery takes place here. That is the CPC's very comprehensive scheme is there. Then take, for example, in the CRPC also. It is not just learning about CPC and Evidence Act. So even the CRPC also contain the rules of evidence. So the documents are introduced for the first time. How? Because you know that the police officer does the investigation pursuant to an FIR lodged under 154. 154 में होने के बाद investigation he commences. After the completion of the investigation, you know that we learned he files a document called charge sheet under section 173. Now, 173 charge sheet must also include documents which I would like to point out. Just open your CRPC, please. If you got open section 173. वहाँ पे document how they are included, I'll point out to you. Yeah. Section 173 खोल लीजिए आप. Now, this is the charge sheet. The police officer files it after the completion of the investigation, where the investigation officer, after completing, files it. When he proposes to proceed, when the report is filed in respect of, pursuant to section 170 of the CRPC. And 170 is a case where the police officer informs the magistrate there is sufficient evidence. So 169 you learned is a case when there is no insufficient evidence or deficient evidence, accused can be discharged by the police officer. Now charge sheet is filed in cases of 170. Now the documents which are sought to be produced, please open subclause 5 of section 173. देखो, when a report is in respect of a case to which section 175 applies, 170 applies, the police officer shall forward to the magistrate along with the report. So 170 CRPC speaks of a case, the charge sheet to be filed when evidence is sufficient. Number one, all documents, see that here, 5A, all documents are relevant extract thereof on which the prosecution proposes to rely other than already sent to the magistrate during investigation. Now, what are the documents which are during investigation sent to the magistrate? No sooner an accused is arrested under section 41. 154 document, that is a section 154 document, is immediately transmitted to the magistrate. Isn't it? That you learned it here. That provision, you can see that here. Transmission, arrest करने के बाद 155 में आ जाइए. Yes. 156 के अंदर and 157 के अंदर. All these documents are immediately transmitted to the magistrate. It cannot be, the police officer cannot withhold it. Number one. Now, during the investigation, you know that here the police officer cannot record a confession. Under 164, the judicial magistrate records it. So those papers are also with the magistrate. Then under 100 and 103 of the CRPC, you know that the police officer record the evidence of panchanamas. पढ़े हैं आपने, हमने बताया था आपको. When CRPC I was taking, please remember this. Now these pancha reports under 100 and 103, just open the CRPC, the document under 103. See, magistrate may direct searches in his presence. All magistrate may direct searches, he may be made in the present place to which he issues warrant. Now 100 में आप check करेंगे, persons in charge to disclose plea to allow searches. Now subclause 3 says that how inspection is to be done before revision. All this inspection report is sent to the magistrate. Now, whatever inspection magistrate takes it, the police officer does it, whatever statements he record, confession he records to the magistrate, he records what you call it, the statements are recorded under 161 and 162. All these are dispatched to the magistrate. So यहाँ पे these are covered under the provisions of section 173 clause 5 5A. आप clause B check करो आप. By the statement recorded under 161 of the person. So the no sooner a person, the police officer FIR is lodged under 154, or arrest take place or doesn't take place, he records the statement of various person under 161. The statements are not evidence under the law. They become only evidence provided all the witnesses whose statements are recorded are examined. Under the section 162 tells you the statements need not be signed. So that must be dispatched and given to the accused person. Then 6 check karo, important. See, even statements which are required to be given are under 207, 2082 CPC, accused person. 207 come into play when under 207, that is when a charge sheet is filed, supply of to the accused all documents. आप check करो 207, 208 में the accused must be furnished FIR under 154. Accused must furnish documents such as under 161.3. Accused must be furnished statements of the police officer under 173.6. I will tell you 176 here. Then come back to 173.6 में आ जाइए. If the police officer is of the opinion that any part of such statement is not relevant to the subject matter of the proceeding, or disclosure to the accused is not essential in the interest of justice and expedient in the public interest, he shall indicate the part of the statement and append it to the ground and standing reason for making. Now, this particular statements under 173.6 our statement essentially are statement under the provisions of section 123 and 124 of the Evidence Act. That I will 123 and 124 of the Evidence Act deal with the statements which cannot evidence as to affairs of the state and official communication which cannot be disclosed to public. Because you know that under the Official Secrets Act, Act of the Parliament, Act of the Legislature, any transaction between the government of India and the state and everything, these are all privileged communication under section 123, 124 of the Evidence Act. Now, there is a leading judgment of the Supreme Court on that point. Sukhender Sindhu's case, that is AIR 1963, I will discuss the judgment when I am dealing with the privileged communication. Because the court will decide the privileged nature and the officer in charge of the of the government, of the head of the department, is required to tell the court whether why should he withhold the document. The court will decide whether the evidence which is sought to be given of privileged nature or not. Huh? Then it is the discretion of the public officer. The minister is required to file affidavit under the law if it's a public document. Take, for example, Raj Narayan versus Indira Gandhi's case, when the election was fought under the Representation of People's Act. Mr. Raj Narayan filed a suit in the Allahabad High Court challenging the election of Mrs. Gandhi on the ground that she indulged in corrupt practices. What is one of the corrupt practices? That Mrs. Indira Gandhi, while acting as the Prime Minister of India, she took the services of the UP government public servants to for public meetings. Public fund का पैसा use किया उन्होंने. So on that ground, that is a corrupt practice. So Mr. Raj Narayan had a very intelligent lawyer, that is Shanti Bhushan, and he summoned all those witnesses. वो सम्मन करने के बाद ट्रायल कोर्ट में ऑब्जेक्शन लिया गया. These are all the evidence falling within the ambit of section 123, 124 of the Evidence Act. So already when the trial of Raj Narayan versus Indira Gandhi was taking place, already we have a matter of a 5-bench judgment of the Supreme Court in SS Singh's case. That citation I will give you. I have it ready with me. That 1961 का judgment है. एक minute, I may be having it here. Yeah, that is the citation is the state of Punjab versus SS Singh. SS Singh मतलब यहाँ पे the gentleman's name was Sodi Sukhdev Singh. It's a well-known judgment on the point of privilege document AIR 1961 Supreme Court, page number 493. इसको याद रखिए आप. I will discuss at one of the point when I am dealing with it here. This gentleman was a session judge in Punjab, Pepsi state. He was dismissed from the services. When he was dismissed from the services, he filed a suit in the he was dismissed in service by the then governor of the Punjab. Then he filed a suit. Suit में file करने के बाद he took out an application under the provision of Order 11, Rule 14. He wanted to know the reason why was it dismissed. The communication between the governor and the department as to why, in fact, the communication said that he should be reinstated. But the government was not willing to produce it on the ground that they were privileged communication. And the minister had sought the opinion of the Public Service Commission. The bench speaking for themselves, that is Justice Gajendra Gadkar's beautiful judgment, which he gave for majority, and which the minority also agreed with the conclusion. That is Justice Subbarao and Justice Thakur, Justice Kapoor. They held the view that here, yes, these are public documents, they cannot be divulged, but the government is required to file affidavit. Affidavit file करना पड़ेगा. The public officer, if he comes to know that the documents are injurious to public at large, it cannot be. And what is public at large? Injury cannot be questioned by the court of law. But as regard the validity of the affairs of the state, the court can question it. मैं बताऊंगा आपको बाद में ये. This is a लंबा judgment है. वो याद रखिए आप. So that is dealt under the provisions of see section 20, section 150 documents mentioned in CRPC में 173 clause 6 and 7 and where the police officer investigate the case, finds it convenient to do so, furnish to the accused all copies. So it is mandatory not only in CPC and in CRPC. Please section 173, 5, 6, 7, 8 को आप अच्छी तरह से पढ़िए. Read with section 207 and 208 CRPC. Of course, I remember having taught you this. I'm sure you will not have forgotten. If you open up the earlier then another important section in CRPC with regard to, because we mentioned to you in the scheme of the in the scheme of this CPC, you can ask for inspection of the document, admissibility and relevancy. Both the parties are required to give the say as to denial and admission. वो दिया गया था मैं आपको, isn't it? In the CPC, the denial and admission under the provisions of Order 11 में दिया गया था. That is Order 11 Rule 13. So CRPC में such a provision you will find. Please open CRPC section 294. You must be in a position to correlate. Please, as a student of law and also as a lawyer, when you go there, 294 खोल लीजिए CRPC बताता हूँ. No formal proof of certain document, that is like an admitted document under section 58 of the Evidence Act, not be proved. Now it says further, where any document is filed before any court by the prosecution or the accused, the particulars of every such document shall be included in the list, and the prosecution of the accused, as the case may be, or a pleader for prosecution or accused, if any, shall be called upon to admit or deny the genuineness of such a document. Please note that section 294 को भूलिए मत गायब. This is a very important document, admission denial in section 294 of the CRPC, yes, which is akin to the provisions of Order 11, Order 11 Rule 22. Order 11 खोल लीजिए आप, CPC बताता हूं आपको मैं. Order 11 से Order 12 में बताता हूं मैं. Order 11 and 12, they deal with the admission, notice of admission, denial with regard to, see that notice to produce, notice to admit document. See Order 12 Rule 2 of the CPC. Notice to admit documents. Either party may call upon either party to admit within 7 days from the date of the service the notice any document saying all just in the case of refusal to neglect admit the document, the cost of providing. So this is an order which the court passes when examination chief is filed under the provisions of 137. Under section 136 of the Evidence Act, the court is called upon to give a finding whether the document should be admitted or not. So उससे पहले the court will call upon the parties, or parties may themselves give notice to each other. And in the CPC, Order 12, Rule 2 CPC, and in the CRPC, it is section 294. Please note that both the sections are very important section, which you must remember them for the purpose of elucidating the subject matter of the case. Now, the another relevant sections with regard to admissibility of the document, apart from section 294, are in the interrogatories which I mentioned to you under Order 11, Rule 1 and 2. Similarly, under section 287 CRPC, 287 खोल लीजिए. Don't think that interrogatories are contained only in CPC. CRPC के अंदर में भी interrogatories है आपको. Section 287 खोल लीजिए आप, CRPC. That is the parties to any proceeding under the code in which commission is issued may respectively forward any interrogatories in writing in which the court or magistrate directing the commission may taking relevant to the issue and shall forward to the magistrate or to the officer. So the exchange of interrogatories are contemplated under section 287 of these all stages where the evidence is introduced in CRPC. Now the analogous provision in the CPC is Order 11, Rule 1 and 2, which I had read out to you earlier. If you open for your information, these are evident rules of evidence. Order 11 खोल दीजिए आप. Order 11, Rule 1 and 2. Yeah. Order 11, or discovery interrogation. See that here. In any suit, the plaintiff or defendant by leave of the court may deliver any interrogatories in writing for examination of the opposite party or one more of the parties, or such interrogatories when delivered shall have the note on foot so and so stating which of the interrogatories so and so. Now, these interrogatories have the effect of an evidence under the law. Please note that here. Now, CPC also contains a provision if it's a public document under the provisions of section 123, 124. Now, that relevant provision you will find under the provisions of open section order 11, order 11 rule 19 subclause 2 देख लीजिए आप. Public document है ना, in the nature of 123 and 162 of the evidence. Yeah, that is, I'm just reading it out to you. Order 11, rule 19, subclause 2 check करिए. When any application for the order of inspection of a privilege is claim for any document, it shall be lawful for the court to inspect the document for the purpose of deciding as to validity of the claim of the privilege, unless the document relates to matters of state. So privilege can be claimed not only by the state, but also by the husband and wife, and also by the advocates and the clients. Those privilege communication during marriage are section 122. You may object here that here the defendant and plaintiff are husband and wife. The communication which has sought the correspondence under the provisions of Order 11, Rule 92 are hit by section 122 of the Evidence Act. They cannot be disclosed. So I told you, you have to file an affidavit disclosing the document which you are not bound. You may say that here, I refuse to disclose this document because these are privileged communication. And similarly, the state, when prosecuting a matter or defending a matter, any Union of India or as any of the state, any of the public servant against whom civil suits are filed under section 80, read with order 27 of the Code of Civil Procedure. The suits are filed, or under the Constitution of India, contracts are entered under Article 300A of the Constitution of India. You know these provisions here. So the state can take up the plea that here these documents are hid by section 123, which say that no one shall be permitted to give evidence derived from the unpublished official record relating to the affairs of the state, except with the permission of the officer at the end of the department concerned, who shall give or withhold such permission as he think fit. So this is a bar here. You cannot do that here. Now, this particular provision has been beautifully interpreted by Supreme Court 5-bench judgment in Sodhi's case. Then 124 says that here, official communication. No public officer shall be compelled to disclose communication made to him in the official confidence when he considers the public interest would suffer by disclosure. Now, the Supreme Court says that while interpreting section 123, 124, it is the public officer or preferably the minister is required to file the affidavit, placing on record that public interest will be injured. Only, and not that every interest of the state should be protected. Certain documents are useless and which are not injuring if your relation with the foreign country are being violated, if they are against the security of the nation can be withheld. It should be injurious to the state, and the court should be the court should be satisfied that the privilege sought is a correct one or not. But if the injury is sought, the court cannot go into it. Now, how section 123, 124 is little subsidized. You may say the condense is under the provisions of section 162 of the Evidence Act, where that is a very important section when it comes to protection of the document. The court can give opinion on that section 162. That is how you read the section. All these sections are applicable to both civil proceeding as well as criminal proceeding. Now, 162 says that a witness summoned to produce, how the summons are issued under the CPC, under the provisions of Order 16 or under the provisions of Order 18. Summons court issue करता है इसके अंदर, and section 30 के अंदर suo moto court that under the CRPC section 61, 62 say 69. So these provisions you remember, please keep your bare act, you will come to know, आपके mind में जाएगा. Now section 162 say a witness summoned to produce a document shall, if in the possession or power, bring to the court, notwithstanding any objection there may be to the protection of his admissibility, the validity of any objection shall be decided by the court. Court को ही power है to decide the privilege. Court's privilege cannot be taken away. There are lots of English decisions which go against, but our government, our Indian Evidence Act chose to follow the Canadian decision and the decision of the Australian decision, which says that here it is the court can decide the privilege. Then subsection 2 says that the court, if it sees fit, may inspect the document unless it refer to matters of the state or take other evidence to enable determine the admissibility. ये admissibility का determine होता है because the moment pleadings are completed, the parties have filed affidavit. यहाँ पे इसको affidavit को examination chief में accept करना नहीं है. Please check section 136. Now it is the question the court has to pass whether I should admit the document or not. Section 136 खोल लीजिए आप. This is applicable to both civil and criminal proceeding. This is all before the commencement of the cross-examination or even the examination chief totally taken on record. Examination chief का document file किया आपने under order 18 rule 4 के अंदर CPC में. There are list of documents which are in the civil proceeding or in the criminal proceeding, the witness is recorded. You are also required to give a list of documents to the magistrate. These are the documents which I propose to examine. So I pointed out to you the relevant provisions in the CRPC, that is the provisions of section under the provisions of section 287 interrogatories लेते हैं इसके अंदर, और under the provisions of 287 and 294. 294 admissibility of the document in CRPC. So the magistrate will see whether the evidence which is tendered and the documents tendered along, like for example, the documents of the police officer under section 173 subclause 5, 6, 7, 8 in the CRPC, whether can I admit them? ये स्टेज में आपको ऑब्जेक्शन लेना पड़ेगा. Now, objection लेने के लिए you please come to section 136 of the Evidence Act. When either party proposes to give evidence of any fact, the judge may ask the party proposing to give evidence in which manner the alleged fact, if proved, would be relevant, and the judge shall admit the evidence if it thinks that the fact, if proved, would be relevant and not otherwise. So if you are producing a public document which will be under section 74 of the Evidence Act, proof may not be required, the court will admit it. Suppose election record produce kiya aapne, or you produce your passport, the court may take on record. You may produce a original of the lease executed by the landlord. A landlord is trying to dispossess you without due process of law. So you say that I am in possession by virtue of the registered lease, which is in perpetuity. The lease is for 99 years. Now the landlord is demanding from me market rate compensation for reason best known to him, maybe with ulterior motives, and he has threatened me with dire consequences. So I have filed the present suit for a declaration that I cannot be dispossessed without due process of law, as per the Supreme Court judgment in Krishna Ram Mahale's case, and also the earlier judgment, and as per the provisions of Article 300A of the Constitution, nobody's possession can be taken away. So the document I am producing is my lease, original registered lease. So the court will say registered lease will come under section 62 of the Evidence Act, which is a primary evidence. A primary evidence is being tendered by you under section 64. The court will record, yes, this is a proper document I am admitting. In case your original document is lost, your original lease is not in your custody. I mentioned to you, you filed the affidavit under order 13 of the CPC. आपने explanation दे दिया affidavit के अंदर. This document is in possession of the defendant or in the possession of the government of India, or the document is lying with the registration office. Then उसके लिए क्या करेंगे आप? You are required to file, give a notice under section 66 of the Evidence Act. मैं बताया last time मैं पढ़ के सुनाया मैं. I won't be again reading it, but keep a track of the provisions of section 66. When you are reading the evidence, you have to inform the court, my lord, the original is not with me. Now, I have given notice under Section 66 of the Evidence Act. Yeah, those of you want to know what is Section 66, please just check it. Rules as to notice to produce. ये notice देनी पड़ेगी आपको. Because you only when you are a good lawyer you will know all this. Evidence Act आपको by heart चाहिए. By heart mean you should remember the CPC, CRPC, Evidence Act. Please note that if you do not know these three together, you will cut a sorry figure. You will not be a good trial lawyer. You cannot. You cannot. You have to remember this. Please remember that. ये notice satisfy करेंगे आप, then the court will say, yes, I am admitting this evidence. The document is taken in record and exhibited accordingly. In case it is not proved, the court will take resort to the provisions of Order 13. Rejection. Rejection, देखो यहाँ पे admission का बताया गया 136 में, you will be confused as a young lawyer. Now the provisions of Order 13 पे आ जाइए. Order 13 के अंदर कहता है कि Order 13, original document to be produced on or before the settlement of the issues. So at the time when the issues are settled, because evidence can be given by the parties for the final disposal of the case or even for settlement of the issues. You know that under Order 14, Rule 5 CPC, I will tell you this is a very important point. At the time when the courts are framing issues, can also tell the parties, I will record your evidence. All of you know that. Probably, I think I never taught you this last year. CPC, whoever has taught you, the professor must have told you, I'm sure. So you'll know that evidence can also be led under the Code of Civil Procedure at the stage of framing of the issues. Order 14 खोल लीजिए आप. Order 14, Rule 4. Rule 4 check करें. Court may examine the witness or document before framing issues. देखिए इधर ये इंटरेस्टिंग है. कोर्ट में एग्जामिन, ये इससे पहले one provision you must know under the CPC, Order 5, court will issue summon to the witness. Order 5, Rule 5, whether the witness summons is being issued for disposal of a suit or for framing issues. Order 5 खोल लीजिए आप. ये सब चीजें आपको रिमेंबर करना है. As a trial lawyer, if you want to be successful, please open Order 5. Order 5, Rule 5 check कर लीजिए. Summons to be either to settle issues or final disposal. Kindly see that here. The court shall determine at the issuing the summon whether it is for the settlement of the issues only for final disposal of the suit, and summon contain direction. So ye provision Order 5, Rule 5 is directly attracted to the provisions of Order 14, Rule 4, where the court say court may examine witnesses. See, court may examine witnesses or documents before issuing premise. So it is not that here this is a stage where even before the parties have filed their list of witnesses. This is a stage even before the examination chief is filed under Section 137 of Evidence Act or under the provisions of Order 18. The court will take up the matter, examine the issue, examine the document, and examine framing of the issues here. That is very, very vital here. So the court will see that in order to understand the meaning of this word, I am unable to understand what the issues are required to be, whether to proceed or not in the matter. इसके लिए examination of the witness is very important. समझे ना? Even under the provisions of a CRPC, starting from 211 onwards, the magistrate may examine witnesses to frame a charge. Court may alter charge. Is the discretion of the judge. See that here? Section 217 में check करें आपने. Recall witnesses when charges are altered. Court may alter charges. So, yes, a provision, even witnesses can be examined by the court at the time of the framing of the issues or alteration of charges or framing of a charges under the CRPC. These are all procedural laws. So, यहाँ पे that is what the why this discussion I am giving it to you, because this applicable section 5 tells you of the Evidence Act, parties can only be permitted to give evidence with regard to fact in issue. Okay, fact in issue देखिए आप section 5 में evidence may be given of fact in issue and relevant fact. Now fact in issue mean fact in issues which are mentioned in order 14 and section 211 से 219 of the CRPC, that is charges. तो उसके अंदर जो चार्जेस फ्रेम किया गया है उसी के अंदर आप एविडेंस लीड कर सकते हैं. और सीपीसी के अंदर इफ यू फाइल्ड ए सूट फॉर अ डिक्लेरेशन that the defendant is a trespasser and he has no right title interest and perpetual injunction is sought by you under the provisions of section 38 of the specific relief act, or you have sought cancellation of a deed under section 32 of the act, you mention that, and mandatory order of injunction is sought. So evidence can only be led within that framework under the provisions of order 14. Section 5 कहता है. Then relevant facts mean you can also proceed further. Facts which are relevant to prove the fact in issue, which are mentioned from section 6 से लेकर, I will tell you, section 6 से लेकर they are mentioned section 50 55 तक, till character evidence, both in civil and criminal proceeding. So the court might ask you, please, you are asking this particular question. For example, in a criminal trial, you may ask a question to the person. Whether you were convicted in a previous offense. बोले ये previous offense, whether the court has passed a disparaging comments against you, are you aware? उसके लिए immediately the judge पूछेगा. Now here the charge is of cheating. बोलेंगे वहां पे misappropriation. But he is not a person of a good character to show that here a bad character, a good character के बारे में, that evidence can be led by the parties in section 53. You have to point out to the court, my lord, this question is relevancy. I am pointing out to you under section 53 of the Evidence Act. That is criminal cases, previous good character is relevant. The bad character comes into play when a man asserts that I was a very good person. Then previous bad character irrelevant except in reply under section 54. You will not be permitted to lead evidence of. So you may take up the plea that at the time of the commission of the offense, which is in Mumbai, I was not there. I was in USA. So you are trying to produce the evidence that I was in London, America. बोलेंगे passport देखिए मेरा, ये देखिए. How it is relevant? So because sometimes irrelevant evidence or inconsistent evidence becomes relevant. That is section 11 के अंदर. You can tell the court why the fact of my serving in America is relevant, because I was not there in Mumbai or in India at the time of the commission of the so-called offense. So I am leading evidence under section 11. इसको बोलते हैं अंग्रेजी के अंदर, ये लॉ के अंदर alibi evidence, ALIB, alibi evidence. समझे ना? Then normally under the another examples I'm giving you of the relevant fact is that here normally Evidence Act, I told you my first two lectures, the court of law accepts only the evidence which is a direct evidence under section 60, the man who has seen it, who has heard it, and who has perceived it with his senses. Number one, or the man is in possession of documentary evidence, the court will accept it. Or the man is in possession of secondary evidence, will accept it. Or the court will draw circumstantial evidence, which I will deal with some of the cases here. But the court will not accept the hearsay evidence. When I heard it from my neighbor, I saw my neighbor shouting, I am staying in a chawl next to the accused person, next to the complainant. He was shouting. Okay, he was shouting His children were shouting that my father has burnt my mother. आवाजें आ रही है, क्या ना झगड़ा हो रहा है, अंदर रूम बंद है, एकदम रूम बंद है, शाउटिंग, छोटे बच्चे दोनों चिल्ला रहे हैं, हाँ देखिए, my father has lit the fire and he has set my mother on fire. रूम बंद है, खिड़की खुली है, और you are a neighbor. You are a neighbor, you are not seen it. But the children के cries आपने सुने, बच्चे रोते हुए चिल्लाते हुए कहेंगे, my father has set my mother on fire with kerosene. Whether this evidence is admissible or not. Anybody knows? Of course, you are not expected to know because you are not attended the Evidence Act lecture so far. Now, this evidence becomes admissible under Section 6 of the Evidence Act. उसको बोलते हैं res gestae rule. That is normally hearsay evidence is not admissible I will discuss it here. Relevancy of the fact forming the part of the same transaction. So the cries, the chilla chilli जो किए बच्चे लोगों ने are related to the commission of the offense where the father, the husband is setting the wife on fire. The children वो जो सो रहे थे रूम में वो चिल्ला चिल्ला के बोल रहे थे और neighbor has heard the cries. Now that if you see the illustration to section 6 उससे साबित हो जाएगा आपको fact which though not in issue. देखो that fact is not issue के neighbors ने देखा चिल्लाएगा is not an issue, or so connected with the fact in issue as to form the part of the same transaction or relevant when they occurred at the same time and place and different time at so and so place. Now illustration कहता है कि A is accused of the murder of B by biting him. A is beating him. Whatever was said by A or B or by the bystanders at the beating or shortly before, after it formed the part of the transaction is relevant fact. सो चर्चगेट स्टेशन में उतरे आपने रेल से, हम आपने देखा कि मॉब ऑफ 100 पीपल सिटिंग, देखिए ये क्या नाम है, इसको मार दिया मार दिया मार दिया, मर गया मर गया मर गया, हाँ बोलिए पर्सन विथ रेड पैंट एंड रेड शर्ट हैज किल्ड द जेंटलमैन, ही इज ओवर हिज हेड एंड उसको मार दिया somebody with a black pant. तो you have not seen exactly, you are unable to see 100 आदमी खड़े हुए उधर, बट आपने you heard the cries. You heard the cries, you have a right to go and lodge a FIR with the Marine Drive police station if you have heard this. So your information will be treated as FIR. And whatever you heard it from the mob is admissible under Section 6. Though it is hearsay, but it is a spontaneous reaction. It is a concurrence of the event which has taken at the time when you are present, which you heard it taking place at the same time when you are present. So this is one departure from the normal rule under the Evidence Act that hearsay evidence is not admissible. यहाँ पे it becomes admissible. यहाँ पे it becomes admissible. It is also called a derivative piece of evidence. So it is not always that here the hearsay evidence is not admissible. यहाँ पे एक example है. Then hearsay evidence is also becomes admissible under Section 7, where tape record evidence is recorded by A and B and C. मैं बताऊंगा उसको, relying upon R.M. Malkani's judgment in the year 73. Now, which somewhat the Delhi High Court recently has taken a divergent view, and illegally collected evidence cannot be relied upon. But it has been the rule in the Indian constitution, Indian administration, Indian law from the year 1960 at least onwards, which I know there are judgments which say we follow the English rule. The English rule के अंदर illegally collected evidence can be used if it is relevant. If it is relevant to the fact and issue, the court is not going to see to whether you have breached the privacy of XYZ by recording. That is not immaterial because none of your fundamental rights are absolute according to me. And the Delhi High Court judgment which I sent to you recently, according to me, has taken a wrong note of it because the single judge has given. The division bench उससे पहले एक महीना पहले has taken a view that here Justice Bimbani has taken a correct view. Illegally evidence can be used, That was also the view of the Supreme Court in R.M. Malkani's case, yeah, 1973, and also in Nagri's case, which I will discuss with you, and also the Rafale's case, because वो अमेरिका में forbidden है. In some of the states, अमेरिका में foreign USA में it is called illegally evidence is called, it is the fruits of forbidden tree. It's a fruit of poisonous trees. क्या बोलते हैं? Fruits of poisonous trees cannot be relied upon in the American Evidence Act jurisprudence. But English law has made a departure when you follow the Nazir's case and other cases. Some of them I will discuss it here. That is what here. Okay. So this is a beautiful piece of legislation, and how when you just I given these three lectures taken to you by way of introduction, just to open up your eyes. So the Evidence Act is not applicable to all the forums. It is applicable to judicial forum, civil courts where they are capable of recording evidence, criminal courts such as Sessions Court, High Court, Supreme Court. Yes, of course, they are courts. And the judicial magistrate, first class, second class. They are courts. They can record evidence. That is the scheme. They are the executive magistrate. Normally, a collector of police. They are not judicial person. Though they are recording evidence, but they are not courts. The tribunals are not courts. The arbitrator is again not a court. The consumer court is a tribunal, is not a court. So the strict rules of evidence are not applicable that is how the system works here. Then the Evidence Act tells you what is expected, why the Evidence Act is there for the purpose of setting the law into motion, for the purpose of proving the substantive right of the parties in a procedural law. In a procedural law, for example, under the CPC, CRPC. And the CPC, CRPC is an interconnected law. It's a law which is it's a connectivity law, I would call it here. It is also a kind of a procedural law which connects to the substantive and procedural law and tries to attempt and tell that how the facts which are introduced, how the plain and written statement you have brought, how it can be proved before the court of law, how the rights which are asserted and denied can be proved before the court of law. That is why we have expression called proved, disproved, and not proved. वो बराबर से पढ़ेंगे ना आप. For the purpose of proving, normally in the examination chief, whoever files the examination chief, for example, the plaintiff, he would like to prove his case. So if I file a suit against you for a declaration that I am the owner of a particular plot of land, it is my wish to prove the case. So that the documents proved, the court will see what documents Mr. Shah has proved before the court of law. So you are interested in denying my legal right. You will take up the plea that he is not the absolute owner of the right. In fact, a mortgage has been created or an irrevocable license was created by my late father in your father's favor. An irrevocable license under the Easement Act section 61, 62 gives you a legal right to occupy. So you will lead evidence to disprove my case. So what evidence you lead in cross-examination, the questions you put me, or you have a right to examine your witnesses, that is called disproving my case. And proving and disproving and not proving, if none of the parties lead evidence, if I don't lead my evidence to prove my document, nor you cross-examine me to dislodge my case, then it is called not proved your case. Then similarly in criminal prosecution, a public prosecutor will take up the plea that here he will describe a charge under the provisions of the session trial which is conducted under section 225 CRPC, that A has committed the murder of B. Okay. Yeah, he should be, it is a gross act of commission of the offense, and no leniency should be shown. And the prosecution has clinching evidence in the nature of 161 recording statement and the nature of a confession under 164. and we have direct witnesses. We have a report of the chemical analysis. We have a report of the DNA officer. We have a report of the report of the handwriting expert. We have various evidence. My lord may permit me to lead evidence on that count. That is called, he is asserting, the public prosecutor is trying to prove the case beyond reasonable doubt by placing before the court direct evidence under section 60, documentary evidence under section 62, circumstantial evidence under the various, under 114 of the Evidence Act, presumptive, non-presumptive evidence under the provision of section 4, may presume, shall presume, conclusive proof. So that is the interest of the public prosecutor, a police officer, to lead evidence beyond the reasonable. Usme accused will take up the plea. The offense was committed by me under grave and sudden provocation. So he's trying to disprove the fact that it is not a murder, it is not a culpable homicide, within it was not at all intentional act. It happened accidentally. I was insane person, or I did not understand the nature of the offense. Then he is seeking to claim exemption under the provisions of section 84 of the Indian evidence and under the Indian Penal Code. You know that these are exemption. So he will try to lead evidence. That is, he will disprove the case. The public prosecutor is trying to prove the case, he will disprove the case. Or he will take up the plea that here the prosecution has not led evidence. There is no direct evidence. There is the evidence which is led is not reliable at all. None of the all are interested witnesses. So the evidence is that is the public prosecutor or a police officer is intending to prove the case by leading evidence, and accused is intending to disprove the case. When both the parties have not led evidence, the case does not stand proved. Not, it is called not proved category. The court will take up the issue that here, then the accused is entitled to benefit of the doubt and should be discharged because the prosecution has not been able to lead evidence. Whereas so the rule of evidence in the criminal prosecution is very strict, lead beyond reasonable doubt. Except in certain cases where you are allowed to draw certain presumptions, presumption which are recognized in CRPC, presumption which are recognized in the provisions of the Indian Penal Code and under the provisions of Evidence Act. But whereas in civil cases, the nature of evidence which is which is appreciated is the court is giving more indulgence to the parties. You are not required to read very strict evidence. You are evident, you are required to prove your evidence on the basis of a not strict proof but preponderance of possibilities. Court may think that it may have happened, it is possible, it is so, it happened. Samjha na? The reason why he is not getting the document because it will go against him. Huh? There is a Stoppal Doctrine can be taken into consideration. He made assertion that I am the owner. On the basis of its assertion, he purchased the property from him, and he denying it, and he had taken the plea. I am holding a will of my grandfather, so he sold the property. He took he earnest money ले लिया 50 लाख रुपया. बाद में बोलता है कि will लेने के बाद no, at the time of the contract I was not the owner. The court will say that no, that kind of stand is dishonest. So there is a estoppel plea will go against you under 115 of the Evidence Act. At the time of the filing of the suit, you may not be the owner, but subsequently you became owner. Huh? You were a joint owner along with your mother, which you suppressed from the defendant. He can file a suit for specific performance. Under Section 12, the court can compel you. There's a concurrence of the parties can be obtained, and you were hidden from the defendant that the property has been mortgaged. You created an English mortgage or usufructory mortgage. So the defendant can file a suit for specific performance under Section 10 and Section 13, giving and joining the mortgagee as a party. So the court can draw presumption that the act of creation of a mortgage has taken place to defeat the right of the plaintiff. So the court will presume that here the act is dishonest. So these are the beautiful presumption. We'll discuss it here. Then another section, section 32, tells you how the hearsay of evidence. It's a ब्यूटीफुल क्लासिकल केस, 8 illustration है उसके अंदर, how the evidence is to be accepted though the person who gave evidence is not before the court. He is not available, he cannot come, he is dead, मर चुका है या आउट ऑफ इंडिया है और बेड रिटर्न है या सम रीजन है, still his evidence is believable. That I will discuss it with you. So these are all these 3 introduction lectures. So far, I do not want to go. Introduction can go at any length. I do not want to carry further. So from tomorrow's lecture, we'll be reading the Bear Act and explain each provision, connecting it to you with not only just one section, connecting it to other section. Because we will be connecting it to sections in CPC and CRPC under the Stamp Act, under the provisions of the various schemes of the Act, Bankers Evidence Act, various वो सब रखिए आप, ये keep a general clauses act, ये सब बताऊंगा आपको मैं, how the evidence act to be connected. It is not just the evidence act अकेला है, Bankers Evidence Act भी है, दूसरे भी 2-3 evidence act भी हैं, how the commercial transaction में क्या लगता है वो बताऊंगा आपको मैं. So our lectures will actually commence with section 1 onward. Step by step, I will go through from the next lecture, that is on Wednesday. I am prepared to take the lecture. I don't think anybody wants to bunk it, isn't it? Isn't it? Kumar, is it okay?
Sure, sir. Yes, sir. Yes,
Yes,
sir.
I am okay. I am okay. Anytime we can take in the mornings. Evening ही रखे अच्छा रहेगा. More suitable. I am taking to your lectures and also within. थोड़ा जल्दी भी करने का तो I don't mind बता दीजिए आप. So this is are
Sure.
the three lectures today we are completing with regard to introduction, and I taken you through how the act is evidence act plays a pivotal role both in civil cases and criminal cases. Now, anybody has any question, please ask me. And anybody has any query with regard to any books, you ask me, and I will clarify it. Huh? Yeah, try and buy a Bear Act number 1. And those who are student, either buy one Munir ka book or Batuklal ka book le lijiye, or Justice Thakkar ka book le lijiye. That is also useful book. There are big commentaries of leading authors, which I told you. You may also go through if you want, but I don't think you will have enough time to read the, because in our days we used to buy the commentary because we never had access to Google. अभी आप गूगल खेलें तो पूरे जजमेंट मिल जाते हैं सुप्रीम कोर्ट के. So read a Bear Act and read the judgment of the Supreme Court. So your mind will be open exactly how to connect it. So that is the advantage of being having a Google. Google के ऊपर all judgments are listed at the Supreme Court, Privy Council, Federal Court सब list हुए हैं. So according to me, don't waste your time reading commentaries which are misleading, most of them, but some of them provide you very good information. The purpose of reading a commentary is to get to know the judgments, Supreme Court के, High Court के various views. So ये अभी आपको गूगल पे मिल जा रहा है. So if you are access to library, then get hold of it. According to me, these books are very expensive, running into 2,000, 3,000. Don't waste your money. If you want to, if you are a person ambitious, having a fire in your belly, and go ahead and purchase it. No problem. I am not saying no to that, but available hai. But Bear Act possession, if you understand the Bear Act correctly, and you will score a first class. I'm telling you that. If you read the बेयर एक्ट में पूरे illustration proviso ठीक से पढ़ के समझ जाएंगे आप, you will be a first class student not only in the class, and also you will be a first class lawyer. Because many of the lawyers, I must say that we don't remember in the court of law the various provisions of either CPC, not CPC, nor Evidence Act. ढूंढते रहते हैं मानो, many of them seniors are banking with the help of the junior. ये देखो बताओ ये किधर है वो किधर है. But according to me, you make your foundation right now. Like I pointed out to you, it is very systematic. Both CRPC, evidence law is nothing but common sense. If we exercise our common sense, we can list it here. How the provisions are to be enacted. Jurisdiction के provision अलग कर दीजिए आप. Plain के लिए, complaint के लिए, investigation के लिए, written statement के लिए provision document क्या है इसके अंदर. It's very beautiful act. According to me, it's like a water flowing from the Ganges. सीधा ऊपर से नीचे जाता मालूम है. समझ जाएंगे तो आप. Okay. So we will end there today's topic, and anybody has any question, I will take it up because I have specific relief act lecture for the Delhi students. बताइए, समझ में आ गया आपको? Anybody wants to ask any questions? So introduction में तीनों lecture खत्म हो गया. I will be taking from starting from section 1 onward, because we'll be going pretty fast. Don't worry, because it is not just one section. We are connecting with section Y to 65, 67. Power of the court. Power of the court will be coming under 160, 165. Huh? So you cannot say that I will go by section 1, 2, 3, 165 last में पढ़ूंगा. नहीं, you have to connect it. uh, when you have to produce a document, draw a presumption. Presumption the 114 के अंदर है. A witness is required to answer all questions, he cannot deny. 133 के अंदर है. So you cannot say that I will go by step by. So we have to interconnect it. Privilege communication था mentioned as a 122, 23, 24, 25, 26 के अंदर. So ये document पहले भी आ सकते हैं. So under the CPC के अंदर I mentioned to you, under the provision the order 11, 19 सब clause 2 के अंदर आते. तो CRPC के अंदर आ जाते हैं. Section 173 सब clause 5 के अंदर आते. So these are mentioned. Even CRPC के अंदर there's a provision called with regard to mint. Have you heard of mint document, which I had mentioned to you? Documents of the mint. उसके अंदर भी प्रिविलेज कम्युनिकेशन मेंशन किया है. आप देख लीजिए. दैट आई विल गिव यू सेक्शन 200 एंड इट्स a very interesting section where there's a reference to yes.
Excuse me, sir.
Hmm.
Sir, it's 6:46. You will have to prepare for your next lecture.
Yes, I am preparing. Don't worry. That I am just pointing out to you one relevant section. Evidence of the officers of the Mint 292 खोलो, वहां पे भी आपको section 123 का reference किया है. 123, 124. So that is how I'm just saying, I'm trying to connect it to you. Privilege communication के बारे में section 292 खोले, evidence of the officers of the mint. Mint printing notes. Coins जो printing करती है गवर्नमेंट ऑफ इंडिया के. So all document purported to be the report under the hand of the officer printing so and so. इनका report itself is evidence and they need not be called as witnesses. Section subsection 3 कहता है कि without prejudice to the provision of 123, 124 Evidence Act, no such officer shall accept with the permission of the court, so and so. So यहाँ पे privilege communication आ गया. So this privilege communication 123 Evidence Act भी लग गया and order 11 rule 19(2) भी लग गया. तो CPC के अंदर section 292. So you should remember this. पेंसिल रख के आप मार्किंग करके रहो, मालूम मत पड़ जाएगा. ये 292 is equal to 123, 124 of the Evidence Act and order 11 rule 193 of the CPC and also section 173 subclause 5 of the CRPC. Okay, आज के लिए stop करें, बस हो गया. Anybody has any question? Last